Hello everyone, and welcome to today's video. My name is Melanie Martin. I am the Director of Dental Hygiene Practice for the Canadian Dental Hygienists Association, and I'm delighted to be your host and moderator for today's discussion. Thank you for joining us. I'm here today with Stuart Rudner, employment lawyer and mediator for Rudner Law. Trained in alternative dispute resolution techniques, Stuart sees employment law from many perspectives and has done extensive work in the dental industry. We have come together today to provide you with answers to your pressing employment questions. Stuart will provide an introduction followed by a series of questions and answers. Hi Stuart, thank you for joining us today.
Hi Melanie, and thanks so much for having me, and thanks to the CDHA for partnering with Rudner Law. We're pretty excited to put together this video and the FAQ that will go along with it, which hopefully will help everyone navigate through these very unusual and unprecedented times that we are going through. And really our goal at Rudner Law generally, and certainly the goal in doing this today, is to help people make informed decisions. And one of the biggest challenges that we see at Rudner Law all the time, not just in the COVID-19 era, is the fact that people do not take the time to understand their legal rights and their legal obligations in the context of their employment relationship. And they often don't even treat the relationship as a legal relationship. And what's interesting to us is people both underestimate and overestimate their rights. They underestimate them in the sense that many people were sent home 2 months ago and didn't even think to question whether their employer had the right to lay them off or reduce their wages or reduce their hours. And yet at the same time, they overestimate them, because now we're starting to talk about getting back to work, which I'm quite happy about. And people seem to think they have the right to choose not to go back to work if they're called back to work. All these things create risks, and we want to make sure people are making educated decisions and not risking their rights and basically risking their livelihood at this really critical time. So hopefully, as we go through the questions today, we will answer a lot of the questions and give people some guidance so they can avoid making mistakes which could jeopardize their income or their jobs in some cases.
Great.
So being a lawyer, we do have to include a disclaimer. Just to remind everyone that this information is supposed to be for information purposes. It's not intended to replace legal advice. And especially in these very unusual times, it's really important to get advice based upon your specific circumstances, because most of the laws and the discussions we're going to talk about today are general in nature, and you need to understand how they impact you. And it's also really important to mention that things have changed so quickly over the last 2 months that even the information in these slides and that we're going to talk about today may not be quite right or quite accurate 2 weeks or a month from now. And we've seen this with presentations we've done over the last 2 months. So be very careful about relying upon this without getting up-to-date legal advice, because you don't want to make a mistake again that will compromise or sacrifice your rights. On that note as well, it's important that people understand that there's a very important distinction between being an employee and an independent contractor. And as Melanie said, we do a lot of work in the dental industry. We work with a lot of hygienists. I know that a lot of hygienists are treated as or paid as contractors. And in some cases, they are truly independent contractors. In some cases, they're really employees in all but name. And so it's important to know two things. First of all, your rights, if you are an independent contractor, will be very different than if you are an employee. But it's also very important to note that no matter how you portray yourself and how you're paid, if there is ever a dispute as to what the nature of your relationship truly is, CRA or the courts will look at the reality of the circumstances and the factual relationship, as opposed to what a contract says. So even though your contract might say you are a contractor, you may have rights as an employee if it's really an employment relationship.
Great, thanks, Stuart. So we'll get to the first question. If a dental hygienist has a contract outlining wages and hours, can an employer negate that contract and force the employee to sign a new contract or terminate them if they don't?
Yeah, thank you, Melanie. So one very important point to make. It's important that everyone understands every single employee in Canada has a contract. Some of them are written, the vast majority are not, in which case their contract is basically comprised of the verbal discussions they had, some rights that are implied by law, and the established practice between the parties. But no matter which form of contract you have, an employer can't unilaterally impose substantial changes to any fundamental term, such as wages or hours, without the risk of triggering what we call a constructive dismissal.
Thanks. Can you explain what a constructive dismissal is?
Yeah, I think it's important to address that because there is a lot of misinformation out there. So the definition of a constructive dismissal is that it is a unilateral and substantial change to a fundamental term of the employment relationship, unless the employer has the right to make those changes. So some key points here: unilateral, it's got to be imposed upon you. If you agree, it's not a constructive dismissal. Substantial, obviously, it can't be a nominal change of reducing your pay by 50 cents or something like that. And it's got to be to a fundamental term of the relationship, which would include things like hours of work, duties, compensation. And if there is a constructive dismissal, it's similar to just being dismissed in the regular way, in the sense that you could be entitled to either notice or severance. But it gets very complicated because, of course, there's usually a dispute about what is substantial, what is fundamental, whether it was agreed upon or not. So it's important to get legal advice before you take that position, because if you do that and you're wrong, you've effectively lost your job.
Thank you. So in this scenario where an employee has accepted a layoff and is either collecting this Canadian Emergency Response Benefit or employment insurance, and the employer calls them back to work, but changes the work environment to the extent that would be considered constructive dismissal, would the employee be eligible for severance pay?
So I'll give you a typical lawyer's answer of it depends. It does sound like that could constitute a constructive dismissal unless the employer had the right. So for example, your contract might say that your hours are not guaranteed and the employer has the right to change them, in which case it would not be a unilateral and substantial change that was not contractually warranted. However, if it is a constructive dismissal, the first thing that you're going to want to do is confront the employer and have a discussion with them and raise your objection and give them the chance to fix it. And if they realize that they may not have the legal right to impose it, they may change their mind. If they still refuse to change their mind and they insist upon these changes, you've really got three options. One is that you can accept the change, either explicitly or implicitly, by simply continuing to work under the new terms. The second option is you can reject the change, resign, and then make a constructive dismissal claim, which, as I mentioned before, can be risky because if you're wrong, you've now given up your job and you have no income and no compensation. And the third option is to continue to work, but also take the position that you don't accept those changes and that there has been a constructive dismissal, and essentially reserve your rights to bring a claim in the future. It can get very complicated, and you're certainly going to want to get legal advice before you take a position, but you're also going to have to weigh the pros and cons. And a lot of people over the last 2 months have been asked to accept either layoffs or wage reduction or cuts in hours. And they've decided that even though it was not the ideal situation, it was better than taking a step which would basically leave them without a job. So you're going to make a practical decision, but you're also going to want to make a decision based upon legal advice so you understand your rights.
Great. So another little bit different scenario, an employer contacts an employee asking her to return to work and informs her that her wages will be reduced significantly. Should the employee return to work and negotiate later or refuse to return if they are unwilling to accept the lower wage?
Yeah, so very similar to the last question, and you're going to have to assess a few things. One is the practical impact. Is it worth accepting a bit of a short-term loss in order to protect your long-term employment? And a lot of people have made the decision that it is. But you're also going to want to have that legal advice. Is it a substantial change? And I think there's reference in the question to reduction by half. I mean, obviously that to me is substantial. There's a lot of myths out there about what is substantial and what's not. A lot of people say if it's less than 10%, it's not. Some people say 15%. I've heard 30%. I usually say if it's less than 10%, it's probably not going to be a substantial change. Anything beyond that is open to argument. And certainly once you get to 25 or 30%, it probably is. But as well, there's enough discretion here that judges will take into account the circumstances. And in this COVID-19 unprecedented situation, there'll be a little more, I suspect, a little more leeway given to employers who are trying to continue operating and basically make the best of a bad situation. So you're going to want to be very careful before you make a decision. But if you do feel that it's not, it's untenable to accept these changes, and it is a constructive dismissal based upon the advice you got from a lawyer, then the best strategy is going to be to confront the employer, give them the chance to change their minds, and if not, then you may want to take that position that you have a constructive dismissal claim and pursue compensation.
Great. So that would be similar as well for not only wages, but other things such as hours, correct?
Yeah, any fundamental terms. So duties, hours, wages, those are the core ones. Other ones you would have to get legal advice, because sometimes even things like, work location, maybe you always work in one room within the clinic, but you're now being asked to change rooms. Most of us would say that's not a substantial change, but there might be some prestige or other benefit associated with that room. So even that could constitute a constructive dismissal in some cases.
Great, thank you. So that answers what typically constitutes substantial changes to employment. And you mentioned around 25 to 30% would typically be significant enough to be considered a substantial change, whereas 10% would not?
Typically, and I think it's important to remember there are no absolute rules here. So every case will be assessed based upon its own circumstances. But generally speaking, 10% is probably not. I would say 25% plus definitely is, but everything in between there is a gray area where it might be. So don't assume that you don't have a claim just because it was, let's say, 18% or 20%. You may well have a legitimate claim to make.
Great. Does the law make exceptions between a temporary reduction in wages versus a permanent reduction in wages?
So generally speaking, there isn't an exception, and a temporary change can constitute a constructive dismissal. And again, temporary layoff is perhaps the best example. A lot of people were temporarily laid off in March and April, or even more recently, and that can constitute a constructive dismissal, even though it's temporary. However, that's going to be a factor in assessing whether the change is substantial enough to constitute constructive dismissal. For example, if it's a 20% cut in pay, but it's only going to last 2 weeks, first of all, is it substantial enough? Maybe, maybe not. But from a more practical perspective, are you going to want to bring a claim based upon a loss of 20% for a few weeks? Practically speaking, it's probably not worth it unless you have another job you can go to, which is the other factor to bear in mind, which is basically leverage. If you have other options, then you're going to be in a stronger position. If you don't, and in the current circumstances, most people don't, you may have to accept more changes than you normally would in order to keep your job.
Great. We have another scenario where an employer terminates an employee due to the effects of COVID-19 on their practice, and then the employer hires another dental hygienist. Is the dental hygienist who was terminated entitled to severance pay?
Yeah, it's a very interesting question. So first of all, anytime you're dismissed on a without cause basis, which clearly this would be, you're entitled to either notice or pay in lieu, which we often refer to as severance. And contrary to popular belief, that can be a pretty extensive entitlement, especially if you don't have a contract which limits your entitlement to severance. It could be up to 2 years in some cases. So people often walk away and accept a nominal severance package when they're entitled to a lot more. So yes, you would be entitled to severance in that case because you've been dismissed without cause. The other factor here is the potential for a bad faith claim. There is a law that says that employers must act in good faith in the course of dismissal. And one example of bad faith is dishonesty. So if you're told that effectively your position no longer exists, and yet someone is hired to replace you a week or so later, that suggests dishonesty, which can entitle you to additional compensation because of that over and above severance.
Thanks. Changing gears a little bit here, does an employer have the right to insist that an employee take vacation or to deny an employee's scheduled vacation time?
Yeah, so generally speaking, employers have the right to determine when any employee, including a hygienist, takes vacation. Now, that'll be one area that's different if you are truly an independent contractor. Independent contractors don't get statutory vacation, but if you're running your own business, you're entitled to decide when you work. So you're entitled to essentially give yourself a vacation, and that's one of the important differences between an employee and a contractor. That being said, so yes, employers can decide when you take vacation and they can schedule it. If you already had a vacation scheduled, then they may not be able to change that. And that will depend very much on the terms that are in your contract, but also the policies in the practice. Because generally speaking, once a vacation is approved, it's going to be a lot harder for an employer to then retract that approval. In exceptional circumstances, they may be able to, or if the policy allows them to, then they would have the right.
Does the employer have the right to ask an employee to sign a liability waiver?
Yeah, this is a really important question because we have been getting this fairly often recently. And of course, I understand why. And I understand why an employer may be quite nervous about reopening and bringing people back, and what might happen if COVID-19 essentially spreads through the office, and they want to minimize their liability. But I think it's important to remember that you can't necessarily get out of all potential liability even with a waiver. So first of all, the question was, can the employer ask? You can always ask, but that doesn't mean that there's a right to require that an employee do so. Second of all, even if the employee or the hygienist does sign off on some sort of waiver, an employer can't opt out of all their obligations. In particular, every employer has an obligation to take all reasonable steps to ensure that the workplace is safe. You can't opt out of that. That's required by occupational health and health and safety legislation. So an employer whose staff are returning to work must ensure they are taking all reasonable steps to ensure that there is a safe workplace, and in particular, to minimize the risk of infection or spreading of the COVID-19 virus. They should also keep in mind that employees always have the right to pursue claims or to refuse unsafe work under occupational health and safety. So even if you've signed some sort of waiver, if you feel the workplace is unsafe, I know we're going to talk about PPE soon. If you're not being provided with appropriate PPE, for example, you can refuse to perform work when you think it's unsafe. And none of these obligations or rights would be impacted even if you did sign a liability waiver. So the value of that waiver is going to be minimal. And generally speaking, you can't be forced to sign one anyways.
So then if the employee does sign the liability waiver and gets sick, do they have any legal recourse for lost wages?
Yeah, so again, waiver, you have to really assess what that waiver says and the circumstances in which it was signed, because it may not remove any rights on the part of the employee. As a starting point, it's always important to remember that we have workers' compensation, or in some provinces it's called WSIB, Workplace Safety and Insurance Board, which provides benefits to people who become sick or injured at work. And it's mandatory for some industries. It's not mandatory in the dental industry, but it's still certainly available, and we often recommend to our clients that they do register for that coverage. So if there is WSIB or workers' compensation coverage and a worker becomes sick, they can apply for benefits. If not, many workplaces, many dental practices have their own separate insurance, which you can apply for benefits under. And lastly, if there's no WSIB or workers' compensation, you can bring a common law claim in the courts for damages that you suffered if you became injured at work. And obviously you'd have to prove that there was causation and you suffered a loss, but you can bring that claim. And a waiver could impact that right, but you really have to assess, like I said, the terms of the waiver and the conditions in which it was signed, because it may not be enforceable. And courts and tribunals generally are very reluctant to leave a victim without any recourse. So you'd really have to assess that carefully. And last point, an employer who fails to provide a safe work environment can be subject to fines or penalties under occupational health and safety legislation.
Can the employer terminate an employee if they refuse to sign a liability waiver?
Yeah, it's another question that we have been getting lately. So start from the proposition that you can be let go at any time for almost you can let go at any time for almost any reason, as long as you act in compliance with the law, which means as long as your employer gives you the severance you're entitled to, and that can be substantial. That being said, you can't be fired. And fired, when I say fired, I mean dismissed with cause. If you're dismissed without cause, you don't get notice, you don't get termination pay, you don't get severance, you don't get anything. It's obviously a very harsh result. And in order to be fired for refusing to do something like sign a waiver, that direction is going to have to be deemed to be reasonable. And I think most courts would find it unreasonable to require that you give up your rights in order to continue working. So I don't think you could be fired for cause. You could be let go and given a package unless that's seen to be a reprisal. So again, if you're asked to sign a waiver, you refuse and you're fired, that could be a reprisal, which would entitle you to additional compensation. So you'd get your severance plus additional compensation, and even threatening to fire someone if they don't sign a waiver could constitute bad faith, which again could trigger additional damages in the right circumstances.
Great. So the next question is, does the employer have the right to ask an employee to sign a daily consent form?
Yeah, so I mean, as we were discussing a minute ago, generally speaking, forcing someone to sign some sort of a waiver is not going to be acceptable. Now, this question is a little bit ambiguous because it's not clear on what the daily consent form would be. So for example, a lot of our clients are looking at some sort of testing before they allow people back into the workplace. It could be temperature, temp testing, etc. And that always triggers an analysis of whether you have the right to do so. And specifically, you have competing duties. On the one hand, as an employer, you have a duty to provide a safe workplace. You also have a duty to respect your employees' rights of privacy. And asking them to undergo temperature testing or things like that would be a breach of their privacy. So you would have to justify that the breach, in this case, temperature testing, for example, is a legitimate basis to ensure safety in the workplace, and that the intrusion upon your privacy rights is as minimal as possible. If there's a less intrusive way to do this, that's what you're going to have to do. But if you're signing a consent or a waiver, or sorry, a consent, I should say, each day to consent to temperature testing, for example, that's fine. But if it's more of a waiver, as we were discussing earlier, you can't be required to sign a waiver, which would basically give up your rights.
Right. So if a client or staff member contracts COVID-19 and the office has to close due to quarantine, is the employer responsible to pay the staff's wages during the quarantine period?
Yeah, it's a really interesting question, and it leads to a very strange result. And we saw this quite a bit when the COVID-19 pandemic started. And of course, a lot of businesses and almost all dental practices either closed or reduced their operations substantially. And the interesting thing is that many people were sent home, and they were entitled to statutorily protected or job protected leaves of absence, but they're not paid. Now, in some provinces, Alberta, for example, there's a paid leave of absence for COVID-19 related absences or inability to work. But generally speaking, if you cannot work because of COVID-19, so for example, if you test positive, you can't go to work, you're not entitled to be paid, although you are entitled to a job protected leave. The reverse is true though, if your employer can't allow you to work. So if the practice has to shut down to be quarantined and send everyone home, then technically everybody should be paid. So strangely, you're actually in a better position if you don't test positive than the person who does test positive. But generally speaking, I think it's important to remember that if you're sent home due to the need for quarantine, you may be entitled to a job protected leave. And in some places like Alberta, you may be entitled to pay, but generally speaking, you're not going to be entitled to be paid. You will, however, be entitled to things like employment insurance, assuming that you meet all the criteria, or the Canada Emergency Response Benefit, or CERB or CERB, depending on how you pronounce it, which will give you some replacement income in those cases where basically you're sent home and you can't work.
Thanks, Stuart. What options do dental hygienists have if they voluntarily leave a job?
Yeah, so voluntarily leaving a job is effectively a resignation. It should always be a last resort, because if you resign from your job, you basically have few, if any, remedies. You're not going to be entitled to severance. You're not going to be entitled to employment insurance. You're not going to be entitled to the CERB or the CERB, depending on what we're pronouncing it. So if it's a constructive dismissal situation, for example, as we discussed earlier, then you're not going to want to resign. You're going to want to assert your rights, say that you consider yourself to have been constructively dismissed, and you may be leaving the job, but you're not resigning. If you need time off for other reasons, for example, you have young children at home, you have childcare obligations. Of course, daycares and schools are closed, so you need someone to look after them. You may be entitled to either a statutory leave of absence and or accommodation under human rights legislation. In other words, your employer may have to accommodate your need to look after your children if it is a need and not a preference. And I think that's a really important point. Also important to remember that accommodation doesn't necessarily mean all or nothing. It doesn't automatically mean you can't work. It might mean that you can work reduced hours or some other accommodation to allow you to meet your childcare obligations and still continue working. If, for example, you can't work because you have a medical condition that puts you at a higher level of risk or you're immunocompromised, then again, you may be entitled to stay home while there is this risk, and that would be either a leave of absence or accommodation under human rights legislation, but it would not be resigning. And again, don't resign unless you really have no other choice.
Okay, thanks. So I think you've answered the question, the next question about the options for dental hygienists who cannot return to work because they do not have access to childcare or they are taking care of immunocompromised family members. Do you have anything to add for that?
Yeah, so I got a little ahead of myself, but
That's okay.
Generally speaking, as we said, those are probably the two most common examples of where you may be entitled to a statutory leave of absence and or accommodation under human rights legislation. It's really important to remember that this is need and not preference. So For someone who simply says that I don't want to take the risk of going out in public, that's not a need for accommodation. Or someone who has other childcare options available, perhaps a partner, in-laws, grandparents, whatever the case may be, but prefers not to, that's not a need, that's a preference. And that would not trigger any of those entitlements. So in those situations, if the person refuses to come to work, then we usually advise our clients to deem someone to have resigned, but they could also be terminated in appropriate circumstances unless they have some sort of right to refuse to work. So be very careful before you take that position.
Great. So with COVID-19, people are more concerned, as you've mentioned, about going outside and changing environments. So we had a question from a member asking if an employer can insist that a dental hygienist must stay in the building for the whole shift, including their breaks or unpaid time.
Yeah, it's a great question. I have to admit, I haven't had this one before, so I thought it was quite interesting. And I think it's a great example of where circumstances may dictate that your normal rights can change. You know, so we all know that, generally speaking, your time on an unpaid break is not considered working time. It's your own time to do with as you please. And if there's a place you can stay in the workplace and have a snack or read or use your phone, then you can do so. But if you want to go outside and take a walk or get a snack or whatever, normally you can do that as well. However, if an employer is going to implement policies to basically try to keep the workplace as safe as possible, then it may be justifiable in the current climate to insist that people don't go outside during their breaks. And I'm going to stress the word may. I'm not saying it would be, but it's certainly arguable that that would be a way to ensure the safety in the workplace, which, as I've said before, an employer has a duty to make all reasonable efforts to ensure the workplace is safe. This may be part of that, in which case a restriction on someone's ability to leave the office during their breaks might be justifiable. That being said, it doesn't mean they can then be expected to work. You are still entitled to your breaks, and that will not change. And again, this would be temporary. If there was this type of rule put in place or policy put in place, it would only be as long as going out in public continues to be a risk. Once that changes, things should go back to normal and you should be able to do whatever you like during your breaks.
Great, thank you. As offices begin to reopen, is there any guidelines on how much notice an employer has to give a dental hygienist before they return to work?
Yeah, so generally speaking, the answer is just a guideline of reasonableness. So it's important to understand, I haven't mentioned this yet, but I'll mention it now. Because employment is provincially regulated, every province has its own set of legislation dealing with employment. So occupational health and safety, employment standards, human rights, they're all different in each province. They're very similar, but there are nuances. So when it comes to layoffs and recalls, there are differences in terms of how long you can be laid off and when you have to be recalled or what happens if you're not recalled, etc. But most of them do not require a specific time period for the recall. And in fact, most of them don't even recall that the notice be in writing, although we certainly recommend it. But it's got to be reasonable. And I think it's important to understand the context here. If you are laid off, you're generally expected to be available for recall. Now, nobody's traveling now, but the usual example I give is if you're on layoff, you can't go off to Europe for 6 weeks because you could be recalled. In this case, nobody's going to Europe, unfortunately, but you're going to need to be relatively available. So it's not reasonable to say we need you in this afternoon, but it's not unreasonable to expect someone to be able to come back within a matter of days. And if you can't come back and you don't have a legitimate reason for refusing to come back to work, then you do risk your job. So you've got to be very careful about that.
Thanks, Stuart. The next question is, can an employer force an employee to pay for their own PPE or to purchase equipment or instruments?
Yeah, so this is where you get to the distinction between an employee and an independent contractor. And I know I mentioned at the outset that there's often some confusion between the two, and some people that are called independent contractors are really more like employees. Employees, generally speaking, do not have to provide tools or equipment in order to do their job. That is the responsibility of the employer. And that's one of the tests we look at when we're trying to figure out if someone truly is an employer or contractor, is who provides the tools and the equipment. If you are truly an independent contractor, the situation is very different. And the dentist might provide PPE or other equipment, but that would suggest that you're more like an employee. And it's certainly open to the dentist to say, you're an independent contractor and you are expected to provide the tools and equipment that allow you to perform your services. So that's a very important distinction, and one way that people often like being paid as a contractor because there are tax benefits, but there are also some downsides, and one of them is that you are expected, or you can be expected, to provide your own tools and equipment.
Right. So do independent contractors have a right to be rehired if they have been laid off due to COVID?
Yeah, so it's an interesting question because it again gets to this point I've been making about this sort of confusion between employees and contractors. So contractors would not be laid off. Laid off is something that can apply to an employee. And as I think I mentioned briefly at the outset, even in the employment context, employers don't necessarily have the right to lay people off. So if you were laid off, you may want to assess whether you have any rights to object to that or seek compensation. But if you're an independent contractor, you can't be laid off, and you don't, most most dentists would not have the right to temporarily suspend the contract unless that right is built into the contract itself, which often happens. But if it's not, there may have been a breach of your contract. So you may have rights if someone terminates the contract early. But if the contract just ended in the proper way, you don't have a right to be, I'll say rehired, even though you're not really being hired if you're a contractor. You don't have a right to another contract. You can always try to negotiate one, but there is no right to insist that you basically be brought back. So this gets really complicated because there may not have been a right to cease the contract at all, either permanently or temporarily. But if it was done properly, and if your contract has effectively ended, you don't have a right to another contract, although you can certainly try to negotiate one.
Thank you, Stuart. We're going to move into some health and safety concerns and questions from our members now. Keeping in mind that the regulatory bodies provide guidelines for what adequate PPE is, and that CDHA recommends that dental hygienists work only when adequate PPE is provided, I'm going to ask you a few questions. What liability does the employer have if a dental hygienist is asked to perform work without adequate PPE?
Yeah, so as I mentioned earlier, every province has slightly different legislation when it comes to occupational health and safety, but the gist of it is the same, is that employers are always expected to take all reasonable precautions to ensure the health and safety of their workers. It's no different now than it is at normal times, other than the fact that considerations are different, such as you mentioned, the use of PPE, which is really an absolute requirement at this point. So an employer does not have to guarantee the safety of workers, because that's impossible. They have to comply with their obligations to take all reasonable steps. And as you said, regulatory bodies have laid out very clear requirements as to what is appropriate, including the use of PPE. And it's going to be very difficult for a dentist to justify their actions if they are not following the guidance from regulatory bodies, government, health authorities, with respect to things like, normally for most employers, we'd say physical distancing. Obviously for a hygienist, that's not going to be feasible. And that's where PPE becomes even more important. So if an employer is not following the guidance of the guidelines that they are receiving, there's going to be really an assumption that they're not taking all reasonable steps to protect their employees. And they're going to have to justify why in the circumstances that it's appropriate. And if it's not, like I was mentioning earlier, we talked about what happens if someone gets sick. If someone gets sick in the workplace, they may be entitled to workers' compensation if the dental office is covered. There may be private insurance policies, or they may have a common law claim in the courts. But it's important to remember the claim would not be based just upon the failure to provide PPE. The claim would be based upon getting sick. In other words, there has to be some sort of damage that is suffered by the individual in order to bring a claim. That being said, if an employer is not taking all reasonable steps, including providing PPE where it's appropriate, then they may be subject to penalties under occupational health and safety legislation. That doesn't compensate the employee, but it would penalize the employer.
Great. What are the steps for dental hygienists who are uncomfortable returning to work?
Yeah, this is the question that we're dealing with all the time over the last week or so as people start to get back to business, so to speak. And it's really important to distinguish between being uncomfortable returning to work and feeling as though the workplace itself is unsafe. So I think it's important to understand, or start from the understanding that when you are directed to go to work or to attend at work, you are expected to. It's not an option. It's no different in normal circumstances. If you work Monday and Tuesday, you can't just decide not to go to work on Wednesday. And even if you've been laid off for the last 5 or 6 or 8 weeks and you're now recalled, you can't just choose not to. So there will be certain circumstances where you're entitled to refuse to, and one of those is where you feel as though the workplace is unsafe. And every jurisdiction in Canada provides the right to refuse work where it is unsafe. The first step would be to go to talk to your employer. If you think there's something unsafe, for example, you're not being provided with the PPE that the regulatory bodies are recommending, first step is to go and talk to them and ask them to fix the situation. They, as an employer, then have an obligation to assess that and determine if there really is an unsafe condition in the workplace. If they do that and you as a hygienist are still not satisfied, your next step is to go to your Ministry of Labor. And it's interesting because most of the provinces have really bolstered their forces, so to speak. They've added inspectors from other departments. They've actually, in Ontario anyways, they've reached out to retired inspectors because they know there are going to be a lot of complaints. Interestingly, I heard recently that there have been over 200 complaints filed already in Ontario about workplaces that are unsafe because of COVID-19. And in every case so far, the ministry or the inspectors found that it was not unsafe. And I think that's typically because people are confusing fears about safety in society or going out in public with safety in the workplace. If there is truly an unsafe situation, like again, not using the required PPE, then presumably if the employer doesn't fix it, an inspector is going to say, yes, this is unsafe, in which case you will not have to work. And that's going to be the order that will be made until the employer fixes the situation, at which point you're going to be expected to return to the workplace.
So what happens, Stuart, if a dental hygienist does not want to return to work, even if the workplace, after the workplace has been deemed safe?
Yeah, so that's what I was saying earlier. Going to work, generally speaking, is not an option. It's a requirement. If it's a regular work day and in the COVID-19 world, your workplace is now reopened and you're told to come back to work, you have to come back to work. And there are limited exceptions to that. So basically, the 3 exceptions are if you have a statutory right to a leave of absence. And many provinces have added rights based upon COVID-19. So in other words, if you cannot work because of COVID-19, which is pretty broad, it might mean that you were tested positive, might mean you have childcare obligations, then you have a right to stay at home and your job is protected. And in most provinces, you will not be paid, although in Alberta, there is a provision for payment for up to a certain number of days. That's the first exception, if you have a statutory right to stay home. Second exception is accommodation under human rights legislation. So similar circumstances, if you have a medical condition that makes it even riskier for you to go out in public than the average person, or if you have childcare obligations or other family members that you have to look after because of COVID-19, then you will be entitled to accommodation, which might mean staying home, might mean reduced hours, might mean working from home in certain circumstances, although again, for hygienists, that's not viable. But that's the second exception, is accommodation under human rights legislation. The third exception is the right to refuse unsafe work. And we talked about that already, Melanie, but just to summarize, if there is a legitimate concern about an unsafe condition in the workplace, not just in public generally, then you have the right to refuse unsafe work. And if the employer doesn't remedy the situation, you can contact your Ministry of Labor and they will assign an inspector who will either come to the workplace or even by phone assess the situation and make a determination as to whether the workplace is reasonably safe, I should say. If none of those exceptions apply, you are expected to return to work. All that being said, we've been working with a lot of clients who are dealing with this situation from both the employee side and the employer side. And in many cases, the business is not fully prepared to fully reopen. They don't need everyone back. So it actually works to their benefit if some people say, I'd prefer not to return to work. And in that case, you can simply agree that, in your case, the hygienist will stay on a leave of absence. So there may be a way, forgetting about legal rights for a moment, to reach an agreement as to what's going to happen and allow you to stay home if you would prefer to. But if the employer does insist that you return to work, you're going to have to, unless you fall within one of those exceptions.
As an independent contractor, are my rights any different to refuse an unsafe work environment?
Yeah, so this is actually one area where independent contractors and employees are in pretty much the same boat because most occupational health and safety legislation doesn't refer to employees. It refers to workers. And so as I was saying before, workers are entitled to a safe work environment. Employers or contractors are entitled are required to ensure the workplace is safe. And if it's not safe, then you can refuse to work in that circumstance. And if the dentist doesn't remedy the situation to your satisfaction, you can get the ministry involved to basically investigate the situation.
So Stuart, if an individual becomes sick as a result of unsafe working conditions, what recourse is there?
Yeah, thanks, Melanie. I think it's important to clarify this. I know we've touched on this a few times in different ways. But if someone becomes sick or injured at work, then there are various recourses that can be available. First, there's often workers' compensation or WSIB coverage, which is not mandatory for some industries, including dental practices. But we usually encourage our clients to take advantage of that coverage anyways, because it does provide essentially insurance when employees or workers, I should say, become injured or sick at work. So if you have that coverage, you can make a claim under that program. Many businesses also have separate insurance for workers becoming injured. You can make a claim under that policy. And lastly, you may be able to bring a civil claim or a court action because you became injured. And in that case, you bring the claim against the employer. Important to remember that the claim is based upon injury or illness, not just risk. So just because the workplace was unsafe, you can't bring a claim for that, although you could contact your ministry and report the fact that the occupational health and safety legislation is not being followed. But if you became sick, then like we said, you may have three potential types of claims. You'll need to assess, especially if it's a common law claim that you're going to bring in court. Court actions obviously cost money to bring. You're going to need to assess whether the costs and benefits balance out and whether it makes sense to do so. But that would be an option to pursue if you don't have workers' compensation or some sort of insurance policy coverage.
Great. Can you clarify whether the employer is obligated to attempt to fix the concern or have it addressed, or does the concern have to be resolved before the dental hygienist is obligated to return to the workplace?
Yeah, so Melanie, as we've said, there is always this right to refuse unsafe work. And if there is a finding that the workplace is unsafe, then the obligation is not just to make best efforts, it's to remedy that. And as a hygienist, you would be entitled to continue refusing to work until the workplace is deemed to be safe. There's no rule that says that once the employer starts to try, you have to come back. The whole purpose here is to ensure that people are not working in conditions that are not safe.
Is the dental hygienist entitled to be paid during the time that the employer is addressing the concern?
Yeah, so generally speaking, if basically that's the fault of the employer, and in those cases, in those circumstances, you would be paid. Now, if there was other work that you could be assigned to do, there is this right to assign you to other duties that are safe while the situation is being remedied. But if there is no other work that you can do that is safe, then yes, you would just be paid even though you're not working.
Okay, that's good to know. Thank you. Is an employer obligated to pay for sick days?
Yeah, so the question or the answer will depend upon the contracts and policies in place. And a lot of employers have policies which provide for things like a certain number of sick days every year, in which case, of course, they would have to follow the policy. Aside from that, you then fall back on employment standards legislation. And as I've said a few times, Melanie, that is province specific. Everyone is a little bit different. Most provide for sick days, but most provide for unpaid sick days. There are some exceptions to that, but unless you have either a policy right or a contractual right, or you're in a province that provides for paid sick days, then sick days are not paid.
Okay. Can an employer insist that a dental hygienist be tested for COVID-19 or other infectious diseases?
Yeah, Melanie, this is another really good question, and it relates to a question we talked about earlier about testing and waivers and consent forms and that kind of thing. And one of the points that's important to understand is you're balancing rights and duties here. So on the one hand, employers have employers have a duty to take all reasonable steps to ensure the workplace is safe. On the other hand, they have a duty to respect the employee's privacy rights. And now we're seeing a clash between those two. So anything an employer does, such as requiring that a hygienist be tested, requiring they have temperature testing, that's intruding upon the employee or the hygienist's rights. And the dentist is going to have to justify that intrusion. So first of all, would this be a reasonably effective and reasonably expected way to ensure that the workplace is safe. And the employer, in this case, the dentist, is going to have to justify the fact that this is reasonably necessary. They're also going to have to show there's no less intrusive way to ensure the workplace is safe. So would temperature testing basically do the job and be less intrusive? Would it be less intrusive to simply ask for a doctor's note or some sort of other confirmation? Every situation is going to have to be assessed on its own particular facts. And just because one organization does something doesn't mean others have the right to. And this is obviously very intrusive. So the threshold is going to be high in order for a dentist to justify going to this extreme. We are in extreme times, so it may be justifiable, especially given the close nature of the work that we're talking about. You know, we're not talking about an office job where people can be separated and you can have masks and really control the risk. Here we're talking about hygienists. Is obviously very close physical contact, although that should be minimized as much as possible. So more intrusion upon the hygienist's privacy will be justified, but this one would have to be assessed on a case-by-case basis, because I'm not sure that the privacy, or so the security or safety obligations would go as far as to allow for this much of a breach of privacy.
Okay, thanks. The last question is, are there any special considerations in place for pregnant employees during the COVID-19 crisis?
Yeah, simple answer is that there always are, in the sense that human rights legislation in every province provides for accommodation for things like pregnancy. So if a pregnant employee is at greater risk, and so for example, while most people might be expected to go out in public and go to work, and assuming that proper precautions are being taken, they're going to be expected to do that, a pregnant employee may be at greater risk, and therefore they may be entitled to more accommodation, which might mean being allowed to stay home on leave. Like any other form of accommodation, it's going to be up to the employee, in this case the hygienist, to produce documentation showing that there is a need for accommodation. That doesn't mean producing their entire medical file or going anywhere beyond what is absolutely necessary, again, falling back on privacy rights, but they will have to justify the fact that there is a need, and then the employer, in this case the dentist, would have to assess whether they can accommodate, because any accommodation is always to the point of undue hardship. And that is a high threshold to meet, because accommodation is expected, but that's the process you're going to go through. So the simple answer is yes, there will be different rules for pregnant employees, and they may well be entitled to accommodation beyond what other employees will receive in these times.
Great, thank you for answering our questions, Stuart. Do you have any closing remarks?
Yeah, well, thank you for those. Were great questions. So thank you for asking those, and again, thanks for getting us involved in partnering with our firm. I guess as a closing remark, I'll say what we often say to people is that most of the issues we see are when people don't take the time to understand their legal rights and obligations in the employment relationship. And people often, you know, I'm talking about employees or contractors in particular, people often don't understand that they have rights, and they either leave money on the table or they compromise their position when they don't need to. And at the same time, people often overestimate their rights and make claims and take positions that they can't justify, which effectively risks their job and their livelihood. So I know in cases and circumstances like we're in now, you may have been off work for a while, income may have been limited. It's not a great time. And the last thing you want to do is incur legal costs. But I really encourage people to get proper advice before they make any decisions that are going to impact their rights. And just don't go based upon assumptions. Don't go based upon what you've heard. Make sure you understand your rights, and then make an informed decision, which might mean compromise, especially because we are in such strange times, but at least do that knowing your rights, as opposed to just agreeing to what you're told without even asking. We've been trying to keep a running blog of all the COVID-19 workplace issues. So feel free to check that out. That will give you the answers to a lot of your questions, many of which we have covered today. But also feel free to reach out to us if you have questions, and if we can help you, that's great. If not, there's no harm done. And last thing I'll say is thank you again. Stay safe and stay informed.
On behalf of CDHA, I would like to thank you, Stuart, for joining us today. CDHA continues to actively review and assess relevant information for dental hygienists as it relates to the coronavirus pandemic. Please visit cdha.ca/safety alerts, where you will find a link to an FAQ document reviewed during today's discussion and other updates and information for dental hygienists. You can also find updates on COVID-19 and the workplace at rudnerlaw.ca/updates-on-COVID-19, as Stuart mentioned earlier. Please be well and take care of yourselves during this difficult time.